George Floyd, how could he not be complying when he was face down on the ground, handcuffed behind his back, screaming for his mother as he was dying? And so, there's a whole range of things that we need to talk about, which is how do we police our communities in the first place? Why is violence a solution for everything? Are police officers equipped to deal with things like domestic violence, domestic disputes, mental health issues? And I respectfully say that should not be the job of a police officer. And when we see a lot of the cases that have happened, we've even seen disabled people killed or shot by the police because they didn't know how to relate to that particular part of the community. So it's not just about compliance, non-compliance. It's like, how are police officers trained and what are they actually prepared to deal with and what are they not prepared to deal with? That's the real question to me.
Right, and I brought that up, Kevin, not to be a mouthpiece for the Minneapolis Police Department, but to remember that it was brought up in the trial that was a justification for what Derek Chauvin did, that he was non-compliant. And the jury listened to that and rejected that. In the tortured arc of American justice, how important do you think that is or isn't?
I tell you, of course they're going to bring it up. They're going to bring up a whole bunch of things. I paid attention very closely to the trial. The man was face down, handcuffs behind his back. There was no issue of compliance or non-compliance. There was nothing he could do. There was nothing. This was, in my opinion, a willful act. You see Derek Chauvin's face. He's unemotional as this man is screaming for his mother, and he literally took the man's life by kneeing him to death. And the hope is of myself and other folks who are leaders, activists around the country, is that this gentleman will get the maximum penalty today, because it sends a message not just to Derek Chauvin, but to police officers and anyone who does this, any kind of racial murder, that this is unacceptable, that our lives are valuable, and we need to stop killing people just because of who they are, because we think that they did something that is so egregious that they deserve to have their lives taken. That's unacceptable. That's inhumane, and that's not who we should be as American people.
Kevin, I want to bring into the conversation Lorenzo Boyd. He is the Vice President for Diversity and Inclusion and Chief Diversity Officer at the University of New Haven. Lorenzo, as someone who works with the police department, who works with police departments, what impact, if any, do you see the Chauvin case having had or having in the future?
I think the guilty verdict on all counts was the best possible outcome for policing, because it shows good police officers that they can distance themselves from the stuff that happened with Chauvin. And there's no excusing what happened. So we're hoping that the verdict is also going to give a sentence that actually sends a message to all bad cops that are out there.
And Lorenzo, do you think, based on your interactions with police departments, there is a different conversation about tactics, about terminology, what is compliance, what is non-compliance? How do you de-escalate situations? How do you find ways to mediate situations that are less aggressive than the kind of tactics that either Derek Chauvin used or other officers have used that have had deadly consequences with their own service firearms?
Well, two things I want to mention to you, Major. Yes, it absolutely changed the conversation. And I think the Derek Chauvin video worked its way into every training of every police department, or at least every progressive department around the country. But more importantly, it talks about what happens prior to the fact that people get together. What happens before the initial contact? It talks a lot about building relationships in the community. It talks about how do we avoid getting to this point.
Let me jump in, Lorenzo, because I need to get to the courtroom because Peter Cahill is there. Thank you very much, Lorenzo. And Kevin, the judge is now opening the proceeding.
And for the defense.
Good afternoon, Your Honor. Eric Nelson and Amy Voss appearing on behalf of Mr. Chauvin.
Thank you. We are still, for all those attending, under somewhat modified COVID restrictions, so we are asking that everyone keep their masks on unless they're speaking. I'll ask for people who are speaking to come up to the lectern and use the microphones, and please to remove your mask so that we can hear you clearly, and also to maintain the distances that we have set out in the courtroom. With that, we'll proceed first with the state. Mr. Blackwell, you may proceed with victim input.
Your Honor, we have 4 victim impact statements. We will start with the 7-year-old daughter of George Floyd, Gianna Floyd, who will present hers by video.
What do you miss most about your daddy?
Well, I ask about him all the time. And that's under it.
Yeah. Well, when you ask about him, what are you asking about?
Well, I was asking, how did my dad get hurt?
Do you wish that he was still here with us?
Yeah, but he is.
Through his spirit?
Yes.
Yes. And when you see your daddy again one day, what do you want to do when you see him?
I want to play with him.
What kind of games do you want to play with him?
I want to play with him, have fun, go on a plane ride, and that's it.
Yeah. Would you?
We used to have dinner meals every single night before we went to bed. My daddy always used to help me brush my teeth.
Oh. Do you miss him helping brush your teeth?
Yes.
How do you hope that the world remembers him?
Well, they help him because those mean people did something to him.
Yeah. If you could say anything to your daddy right now, what would it be?
It would be, I miss you and I love you.
All right. Thank you, Gianna. I really appreciate you answering questions today.
That was Gianna Floyd. Your Honor, next we'll hear from the nephew of George Floyd, Brandon Williams. Mr. Williams.
If you could begin by giving us your full name and spelling each of your names.
Brandon Williams, Brandon Williams.
Thank you. You may proceed.
On Monday, May 25th, 2020, George Perry Floyd Jr. was murdered by Derek Chauvin in a malicious and insidious display of hate and abuse of power. Chauvin killed George. Not only did he kill George, but he also displayed a total lack of consideration for human life as he did so. You saw it, I saw it, and millions of people across this country and the globe witnessed the act of hate. A year and 1 month later, I stand there before you tasked with the duty of expressing how George's death has impacted me personally and the rest of our family. As I racked my brain and thought about what I could say today, I came to this conclusion. It is humanly impossible for me to stand here and convey or articulate the right words that would capture all that we are feeling and what we have felt over this period. So please bear with me as I attempt the impossible. The sudden murder of George has forever traumatized us. You may see us cry, but the full extent of our pain and trauma will never be seen with the naked eye. The heartbreak and hurt goes far beyond any number of tears we could ever cry. Words simply cannot express the pain, anguish, and suffering that our family and friends have endured since George's murder. It has been truly unimaginable, but not as nearly unimaginable as the defendant's decision to take the life of a human being with no regard for the effect it may have on others. Although Chauvin will be sentenced today and spend time in prison, he will have the luxury of seeing his family again, talking to them, and he will likely get to spend time with them upon his release. These are all luxuries that my young cousin Gianna were robbed of when Chauvin made the active decision to kill our father. There will be no more birthday parties, no graduations, holiday gatherings, or other family celebrations. The laughter, hugs, guidance, advice, sense of security, and those opportunities to simply say I love you are forever gone. They say time heals all, and while I generally believe that saying, it's challenging to do so given these unfathomable set of circumstances. Before I conclude, I must highlight a few things. George's murder, this trial, and everything in between has been tragic and devastating. Our family is forever broken. And one thing we cannot get back is George Floyd. It is the request of my family that the maximum penalty for the crime for which the defendant was convicted be imposed. On behalf of my family, friends, community, and supporters, I wish to express my sincerest gratitude for allowing us opportunities of expression. Thank you.
Thank you, sir.
Your Honor, first, just for the record, this wonderful lady standing here is a Hennepin County victim advocate.
Ms. Boswell is well known to the court.
Yes, thank you, Judge.
And so, Your Honor, we'll next hear from the brother of George Floyd, Mr. Terrence Floyd.
And Mr. Floyd, if you could state your full name, spelling each of your names.
Yes. Terrence Floyd. That's Terrence, Floyd, Floyd.
Go ahead.
I'm here representing my brother. I'm from New York. On May 25th, 2020, my brother was murdered, everyone knows, by Derek Chauvin. The facts of this case were proven beyond a reasonable doubt, and 3 guilty verdicts have been rendered. This situation has really affected me and my family. Any family member that has went through this, we are part of a fraternity of families, and it's not one of those, fraternities that you enjoy. I just, over this last year and months, I actually talked to a few people, and I wanted to know from the man himself, why? What were you thinking? What was going through your head when you had your knee on my brother's neck? Why when you knew that he posed no threat anymore, he was handcuffed, why you didn't at least get up? Why you stayed there? A month before my brother was murdered, I was on the phone with him, and we had a long conversation. And as I looked at the video of my niece, the last conversation me and my brother had was he wanted to have play dates. He wanted to plan play dates with Gianna and my daughter. And we started setting it up. That can't happen. And I have to, my daughter's still young, but I still have to explain to her, because this is history. This is a case everybody knows about. So she's gonna find out, and I'm gonna have to explain that to her. And I think that's, to me, harder than even just standing here, that I have to talk to my daughter and tell her, about her niece, about her uncle, about the situation. That's basically reliving it all over again, years down the line. I'm here on behalf of my family, on behalf of me and my family, we seek the maximum penalty. We don't want to see no more slaps on the wrist. We've been through that already. In my community, in my culture, we've been through that already. Smacked on the wrist. No. Because if it was us, the roles was reversed, there wouldn't be no case. It would have been open and shut. We'd have been under the jail for murdering somebody. So we asked for that same penalty for Derek Chauvin. Thank you.
Thank you, sir.
Your Honor, the final victim impact statement for the state will come from George Floyd's brother, Phalonis Floyd.
And sir, if you could begin by giving us your full name and spell each of your names, and I have permitted you to use your phone because you have notes on it. Is that correct?
Yes, sir.
All right. And you may proceed when you're ready. Giving us your full name first.
Phalonis Floyd, spelled Philonise, last name Floyd, Floyd.
And you may proceed.
One year ago, May 25th, my brother George was murdered by Derek Chauvin and his co-defendants in broad daylight with a knee to his neck for 9 minutes and 29 seconds. I was a trucker, and immediately my life changed forever. I began to speak to the world for George from the United Nations, Africa, Canada, Japan, and so many other countries. Every day, I have begged for justice to be served, reliving the execution of George, while others begged and pleaded for Officer Chauvin to simply just allow George to take a breath. I haven't had a real night's sleep because of the nightmares I constantly have hearing my brother beg and plead for his life over and over again. Even saying, "They're going to kill me. Please, officer." Screaming for our mom. I have had to sit through each day of Officer Derek Chauvin's trial and watch the video of George dying for hours over and over again. For an entire year, I had to relive George being tortured to death every hour of the day, only taking naps and not knowing what a good night's sleep is anymore. I've been lifting my voice tirelessly every day so that George's death will not be in vain. Honorable Judge Peter Cahill, I thank you for allowing me to share this today. George's life mattered. So my family and I, most of all, my niece, Gianna. My niece, Gianna, she needs closure. I'm asking that you please find it suitable to give Officer Chauvin the maximum sentence possible, charge that he has been found guilty for. My family and I have been given a life sentence. We will never be able to get George back. Daddy's our daughter's first love. He would never be able to walk Gianna down the aisle at her wedding, attend those magical moments of her life like a daddy-daughter dance, sweet 16 party, seeing her out for prom graduations, and she would never be able to have any personal memories with her father. With a smirk on his face and children present, Officer Chauvin used excessive force and acted against his training. Chauvin had no regards for human life, George's life. I stand before you today asking you to please help us find closure by giving Chauvin the maximum sentence possible, making sure he does his time consecutively without the possibilities of parole, probation, or getting out early for good behavior. Thank you.
Thank you, sir. Mr. Frank.
Thank you, Your Honor. Here today, of course, for sentencing, gives us an opportunity to speak about other matters that I think are involved in sentencing and where we are in the criminal justice system in the processing of this case. As a member of an elected office representing the people of the state of Minnesota, as well as people of the local community, I want to say a couple of things. And first of all, I want to really thank some of the police officers in the Minneapolis Police Department who, under great pressure, great stress, and to some extent at peril to their occupations, what they've devoted their life to, stuck to their oath and their commitment as police officers to speak openly and honestly about policing and the training that is given and received by police officers. Those officers didn't hide behind a blue wall. They came forward, they told this court and those jurors what they knew about training and responsibility. And I think they deserve recognition and credit for that. I would also like to thank members of the Bureau of Criminal Apprehension. Those agents get called in, great sacrifice to their personal lives. Whenever things happen, they go. They did that here, and under really extraordinary circumstances, completed a very professional and thorough investigation. Conducting interviews is hard enough, but conducting them in the atmosphere of the city following the murder of George Floyd was even more difficult. And they did so, I think, above and beyond the call of duty. And I want to thank them for doing that on behalf of the whole prosecution staff. Your Honor, I want to thank the family, the loved ones, the friends of George Floyd. They have been through so much more than families involved in murder cases. He's right. It's a fraternity you don't want to be part of. But they've been through so much more because of the pandemic and because of security, safety precautions that we've had to take. They have been through a lot. At a time when they try to grieve, like everybody does for the loss of someone, they are going through so much more. And I want to thank them, all of them, the family. The court saw a testimony from Philonise Floyd, Courtney Ross. These are people who are trying to deal with their loss, but they have to do it in a very public way and under very trying circumstances through no fault of their own. So I thank them. They have all been models of grace and understanding. And it's really remarkable, quite frankly. I'll, I think, come back to them again in a little bit. Your Honor, we have submitted a sentencing brief. I would incorporate that. I guess I would incorporate my comments today into that memo. But I do think there are things that I want to bring out today in my arguments. For hundreds of years, the court had discretion in sentencing. It was the trial court's decision on what a sentence should be. The recognition that the trial court sat through the trial, watched the evidence, and saw how it affected people, informed the court's discretion. When the legislature passed the guidelines, in a legitimate attempt to try and even out sentences, they defined certain presumptive sentences, as we all know, for typical crimes. For each crime, the typical crime. But they did not remove discretion for sentencing judges. They recognized that Nobody is better suited to decide whether this is the typical case represented by that guidelines presumptive sentence, or if there are reasons why this is worse than that. And the guideline still gives this court discretion when there are aggravating factors to give a more serious sentence than what the guidelines presumption calls for. And as you know, we are asking you to do that today. As this court found, there are 4 aggravating factors that we have identified. They go beyond a list of just what those factors are. We have not just done our homework and found a list. The court made good findings, detailed findings about those factors, and we think they justify a greatly increased sentence. This is not the typical second-degree unintentional murder. Supreme Court in our state has said that, and very recently, even 1 aggravating factor is sufficient to go twice the top of the range. Here we have 4. The first one that the court found is an abusive position of trust and authority. And the court specifically found that when Mr. Chauvin was acting as a police officer, he had a position of trust and authority. That is certainly true. We trust police officers. We trust them when we need help. We call them for help. We trust that they're going to take care of the problems that they are assigned to deal with, right? We trust them. We also give them great authority. We give them great power. We give them power to use force that individuals would be prosecuted for using, right? We give them authority to arrest, to detain. And with great power, of course, comes great responsibility. So they're not sent out there by themselves to do this. They're given substantial training. This court saw all of that through the trial in general and in specific to Mr. Chauvin and the other 3 officers. They're given training on the use of force, the proportional use of force. The force used has to be warranted by the threat. They're given training on de-escalation because we recognize that police officers are called in when people are not having their best day, when people might be affected by mental illness, drug abuse, any number of issues. They're just having a bad day, and they're trained for that and should be. And they're taught how to use that to de-escalate and control a situation. They're taught medical intervention. They're taught to provide medical attention to people who need it. Being a police officer is a difficult job. We ask a lot of them. It's a profession, there's no doubt about it. But we give them a substantial amount of training, and most officers do it right. This case wasn't about police officers, all police officers. It wasn't about policing. This case was about Derek Chauvin disregarding all that training he received and assaulting Mr. Floyd until he suffocated to death. One of the things that you heard, Your Honor, and the jurors heard that can really encapsulate, I think, a very important issue here. 7 words: in your custody is in your care. And it's a real simple mantra. It's a real easy thing to remember. You're going to take custody of somebody, you have to provide care. You have to do it in a caring way. You can't simply disregard their care. Mr. Chauvin abused his position of trust and authority as a police officer by doing just that, just disregarding all his training. It was an abuse of that because what did he decide to do? We often are forced in this, criminal justice system to infer people's state of mind by their conduct and their statements. What was Derek Chauvin's endgame here? What was the plan? It seems apparent the plan was hold him down until we can dump him in an ambulance and no longer have him be our problem. You recall he said to Charles McMillan, "It's a big guy, might be on something." That's it. He held Mr. Floyd down as Mr. Floyd begged for his life. He had the other officers help in that regard. And rather than doing the simple expedient of putting him on his side, he said, "Yeah, He was dismissive to that duty of care. We trust that arrestees will be treated with respect, reasonable force, and that their medical needs will be addressed." I'm paraphrasing from the court's findings. That trust was violated. We trust that they will use their authority reasonably. And this was a particularly egregious abuse of that force. Again, paraphrasing the court's findings. The typical second-degree murder does not involve that extent of abuse of a dearly held position of abuse or a position of authority and trust by the community, by individuals of the community. Your Honor found that Mr. Floyd was treated by Mr. Chauvin with particular cruelty. I think tortured is the right word. We know that, we've all seen it. Mr. Floyd did not want to be in the back seat. That's it. That's the rub. It was the need to get him in that back seat no matter what. And we all saw that once he was pulled out of that back seat, he calmed right down, even willingly went down to the ground. "I'm going down," he said. And he went down to the ground, not fighting, not punching. And he was placed initially on his side. He's already handcuffed. He's placed on his side in the recovery position, like he should be, because he's trying to breathe. And then quickly placed prone on the ground, face down. Mr. Chauvin put his left knee on George Floyd's neck, his right knee on George Floyd's back, face down on the pavement. Had Officer King sit on Mr. Floyd's waist area and had Officer Lane hold his feet down. You can even see Mr. Floyd trying to pull his feet up. We all are going to fight to breathe. Everybody knows that fear when you all of a sudden realize you're having trouble breathing. It's just innate, right? We want to survive. We know we have to breathe. And there's an automatic reaction when you begin to feel like that is threatened. And you can see Mr. Floyd going through that. He tries to pull his feet up. But he's held down by these three officers while Officer Tao is looking on. Later, of course, goes to keep the people who want to help away. He's placed face down on this pavement so harshly that it rubs the skin off his face. He has injuries to his face from being face down on that pavement. He has injuries to his knuckles from just trying to lift himself up. And he's telling Officer Chauvin, "I can't breathe. I'm dying." And Mr. Chauvin's response was, And all this time, imagine what Mr. Floyd is going through. If we're going to talk about particular cruelty and torture, really try to appreciate what he's going through. He knows he's suffocating. We all know that feeling of not being able to breathe enough. And he's begging, he's pleading, and he's being ignored. His concerns are being dismissed by somebody who has taken custody but not care. He was kept in that prone position for 9.5 minutes and was suffocated. There's no other way to say it. That's particularly cruel. That is more cruel than a typical second-degree unintentional murder. Significantly more. This is not a momentary gunshot, punch to the face. This is 9.5 minutes of cruelty to a man who was helpless and just begging for his life. This court found that there were children present, standing only a few feet from these officers. These children, who were ages 17 and one child age 9. Why is that an aggravating factor? Well, I think everybody can figure that out, right? It's particularly bad to commit a crime in front of children. We've heard a lot of academia about, the development of the young brain and how long it can take. And here you got a couple of teenage girls, a 9-year-old girl. How are they going to process this? Standing feet from a man being suffocated by police officers. Such a stark sight that one of the children even says, we got to call the police on the police. How do you process that as a 9-year-old? The children were not only present watching a man die. We've all seen, if you haven't, you really need to look at George Floyd's face. As he's dying, he's suffering. The children have to watch this. But not only that, it's police officers, and there are people around them wanting to help. And at one point, and sure, they got upset. And at one point, Mr. Chauvin points his mace, grabs his mace to keep him back. How does a child look at that? There's another officer screaming at them to get back. The typical second-degree unintentional murder doesn't involve children standing feet away watching a 9.5-minute suffocation of a man begging for his life. This court also made a finding that the defendant committed the offense with the involvement of 3 or more other persons. Lane and King were involved directly in the restraint, and that Tao kept the bystanders at bay. I've already talked a little bit about Lane and King's role in holding Mr. Floyd down. They recognized that he was pulseless, that Mr. Floyd was pulseless at one point, and yet really made no effort to take care of the person in their custody. Officer Tao watched most of the suffocation and then only went over to keep people from giving help. One person who is identified as a medical trained firefighter for the city of Minneapolis, and that was dismissed. Like, are we going to believe her? So they kept trained medical people from providing help. These were all uniformed peace officers, adding to that abuse of trust and authority. I know the defense has asked the court for probation. I'm not going to spend a lot of time arguing that. It's so outside of the realm of, I think, real possibility. This is a murder. I understand some of the arguments made on behalf of Mr. Chauvin. I can't understand what his family members and friends are going through. I can't. But it's certainly not enough for a departure to probation for a second-degree murder. We believe, Your Honor, that these 4 aggravating factors and the findings that the court has made certainly justify an upward departure because there are 4 of them, not standing alone, but in a sense, not overlapping, but coming together to show this is not the typical second-degree murder. This is egregious. And this justifies a double upward departure. From the top of the box, which is 180 months, we're asking the court to do a double departure, recognizing all 4 factors, to 360 months. As I mentioned before, Your Honor, this is sentencing. This is the time for victims, right? This is the time for the loved ones of the victim and the community to have a say. Again, I commend this family. I commend all of the loved ones, the friends, the people that have been involved in this case for tolerating and being gracious. None of this, of course, can bring George Floyd back. That's very true. But this is the time for our criminal justice system to say, we hear you. This is the time for their criminal justice system to say, we recognize that this harm you're going through is real. And while we can't feel what you're feeling, we know we can do what your criminal justice system should do and recognize the severity of this crime and reflect that in the sentence to be given. It's time for this criminal justice system to say, we recognize this is more serious than the typical second-degree unintentional murder. The 4 reasons the court found reflect that and give this court more than an adequate basis to do that. Your Honor, we ask the court to impose a sentence of 360 months, commitment to the Commissioner of Corrections. As you know, Your Honor, there are no fines in murder cases. And we would ask the court just to reserve the issue of restitution. We can clarify that with the family and present that to the court for 30 days. Thank you, Your Honor.
Anything further from the state?
No, Your Honor.
Okay. Mr. Nelson. I'm sorry. Mr. Blackwell?
I'm sorry, I just thank you, Your Honor. Your Honor, at this time, the defendant's mother, Carolyn Palenti, would like to address the court.
If you could state your full name, spelling each of your names, and proceed when you're ready.
Carolyn, Carolyn, Palenti, Pawlenty. I am the mother of Derek Chauvin. I am here to speak on behalf of my entire family. On November 25th, 2020, not only did Derek's life change forever, but so did mine and my family's. Derek devoted 19 years of his life to the Minneapolis Police Department. It has been difficult for me to hear and read what the media, public, and prosecution team believe Derek to be an aggressive, heartless, and uncaring person. I can tell you that is far from the truth. My son's identity has also been reduced to that as a racist. I want this court to know that none of these things are true and that my son is a good man. Derek always dedicated his life and time to the police department. Even on his days off, he would call in to see if they needed help. Derek is a quiet, thoughtful, honorable, and selfless man. He has a big heart, and he always has put others before his own. The public will never know the loving and caring man he is that his family does. Even though I have not spoken publicly, I have always supported him 100% and always will. Derek has played over and over in his head the events of that day. I've seen the toll it has taken on him. I believe a lengthy sentence will not serve Derek well. When you sentence my son, you will also be sentencing me. I will not be able to see Derek, talk to him on the phone, or give him our special hug. Plus the fact that when he is released, his father and I most likely will not be here. Derek, my happiest moment is when I gave birth to you. And my second is when I was honored to pin your police badge on you. I remember you whispering to me, "Don't stick me with it." Derek, I want you to know I have always believed in your innocence, and I will never waver from that. I have read numerous letters from people around the world that also believe in your innocence. No matter where you go, where you are, I will always be there to visit you. I promise you I will stay strong, as we talked about, and I want you to do the same for me. I will do what you told me to do, take care of myself, so I will be here for you when you come home. Remember, there is no stronger bond or love than a mother's love. One final thought I want you to remember. Remember, you are my favorite son. Thank you for your time.
Thank you. Mr. Nelson.
Thank you very much, Your Honor. It is my intent that my remarks this afternoon be quite brief. I do not intend to relitigate the facts of this case, nor spend any substantial time looking at the law. The court is very familiar with the facts of this case, and the parties have fully briefed the court relevant to the sentencing factors. And we recognize that in any case, any sentencing that comes before the court is tasked with a difficult job. The court must craft a sentence that serves the interests of justice, a rather nebulous term. The court must take into consideration victim impact, public interest, as well as the circumstances and the history of the defendant. And in this case, more than any other that likely any of us have ever been involved in, that task is exceedingly more difficult. In my remarks today, I just wish to briefly address each of those three considerations, starting with the public impact. As I believe we are all cognizant of, this case is at the epicenter of a cultural and political divide. We tried to keep a lot of that out of the courtroom during the trial and make this case about the facts. But we recognize what has happened as a result of this case. There are a great number of people who will view any sentence you pronounce as overly lenient and insufficient to satisfy justice. But there are an equal number of people who will view any sentence you pronounce as draconian or overbearing. Either way, some percentage of the public will view your sentence as a miscarriage of justice. The intensity of the public interest in this case cannot be understated. I trust that the volume of correspondence that each of us has received from the public at large is indicative of these very sentiments on both sides. As I was informed just yesterday, the Attorney General's office established a website, web submission to accept community impact statements. Again, in my understanding is in a little over 2 weeks, they received over 1,000 submissions. Again, on both sides. By my very best estimate, since my representation of Mr. Chauvin began last summer, I would estimate that I have received over 5,000 emails, over 1,000 voicemails, and hundreds of handwritten letters. Again, from both sides. And I expect that Your Honor has likewise been inundated with public comment and scrutiny. The impact that this case has had on this community is profound. It goes far beyond what happened on May 25th of last year. It has been at the forefront of our national consciousness, and it has weaved its way into nearly every facet of our lives, from the entertainment that we consume to the presidential politics, from protests to conspiracy theories. In the end, it is my sincere hope that when this proverbial dust settles, the community impact brings forth principled debate and civil public discourse, and ultimately leaves a positive effect on the city of Minneapolis, the state of Minnesota, and the United States. But nevertheless, while this court may consider the community impact, it is for these very same reasons that the court must turn to the foundational legal principles and remember that justice is blind. Law is built on reason and common sense, and it cannot be permitted to be assailed by public opinion. Turning to the second consideration, which is the victim impact, the death of George Floyd. The death of George Floyd was tragic. He is loved by his family members. He is loved by his friends. And his death is justifiably mourned by those whose lives he impacted. He is a son, a brother, a father, an uncle, and a friend to many. And as the court heard today, the impact and the loss of his life, simply it can't be simplified. And it will take time. Finally, Your Honor, the court must take into consideration, just like it has to take into consideration the aggravating factors, it needs to take into consideration the mitigating factors. And the mitigating factors as set forth by the sentencing guidelines really point to the TROG analysis, essentially, ultimately in this case. We're not going to spend a lot of time, again, arguing for a probationary sentence. That's briefed. But that being said, when we look at the TROG factors, who is Derek Chauvin? Derek Chauvin spent 19 years as a Minneapolis police officer. He loved being a police officer. I was contacted during the course of my representation and have had numerous conversations with his fellow police officers or fellow police officers that worked with Derek, some retired, some still active. And they told me that he was a solid police officer, that he did his job, that if somebody asked him to do a particular task, he never complained, he did it. One person told me that one of his sergeants told me that if I had asked him to dig a ditch for 8 hours, he would have picked up a shovel and he would have never complained for a second. He would have done his job. He was decorated as a police officer, multiple life-saving awards. He was decorated for valor. He was proud to be a police officer because what he liked to do was help people. And as the statistics show, the vast majority of police work is helping people. He was proud to be a Minneapolis police officer. He served his country as the United States in the United States Army. And he too is a son, and a brother, and a father, and a friend. He too, his life, the life he's lived, he's not coming into this as a career criminal with 6 points, 5 points, 4 points. He's coming into this never having violated the law because he lived an honorable life and he attempted to live an honorable life. Derek Chauvin was not even scheduled to work on May 25th, 2020. He volunteered because there was short staffing at the time. I know from numerous conversations that I've had with Derek that his brain is littered with what ifs. What if I just had not agreed to go in that day? What if things had gone differently? What if I never responded to that call? What if? The truth of the matter is, and the end result is that we are here after a jury verdict, finding him guilty of these offenses. And the court's consideration should not only be focused on the aggravating factors, but the mitigating factors as well. The Minnesota Sentencing Guidelines Commission was established for a reason. And yes, the court in circumstances like these has discretion to go beyond and aggravate a sentence beyond the presumptive sentences established by the sentencing guidelines. But the sentencing guidelines don't differentiate between second-degree murders. Someone robs a liquor store, a police officer is involved in an incident, and a person dies in police custody. The law presumes, the legislature presumes that the sentencing guidelines as established is a sufficient penalty for all of the second-degree murder categories or cases you would see. From 2019 back to 2010, a total of 90 people were sentenced for second-degree murder. Those sentences, those people, there were more than that, but people who had a 0 criminal history score, more than 90 people were sentenced. 67%, or 60 of those 90 people, received a guideline sentence of 150 months. So 2/3 of all people in this same position received a guideline sentence. 20% received an aggravated sentence, 18 of the 90, and 13% or 12 individuals were granted mitigated departures. So if the legislature and the intent of the sentencing guidelines is to eliminate sentencing disparity, the law should presume that the guideline sentence is what is appropriate in this case. Judge may take into consideration at this point those aggravating factors, but you have to counterbalance them, which is the goal of the law, with the mitigating factors. I know that this has been an incredibly difficult case for the Floyd family to have to endure. The state of Minnesota, likewise, the prosecutors in this case have endured quite a bit, as has Mr. Chauvin's family. This is a case that has changed the world to some degree, and I hope it's positive. But it's my hope that the court follows the sentencing guidelines, applies the law in a reasoned manner, and imposes a just sentence.
Actually, Mr. Chauvin, would you join Mr. Nelson at the lectern? Mr. Chauvin, this is your opportunity if you wish to give any input to the court. And so I turn it over to you and your attorney.
Thank you, Your Honor. At this time, due to some additional legal matters at hand, I'm not able to give a full formal statement at this time. But very briefly, though, I
do want to give my condolences to the Floyd family. There's going to be some other information in the future that would be of interest. And I hope things will give you some peace of mind. Thank you.
And I'll note that I did read your comments in the pre-sentence investigation as well.
Thanks, Ron.
All right, we are going to take a 15-minute recess so that I can complete the sentencing order based on what I've heard today. And let's reconvene at 2:45. We're in recess.
Peter Cahill ordering a recess in the proceedings that will lead to the sentencing of Derek Chauvin, the former Minneapolis Police Department officer convicted of second-degree murder in the death last May 25th, 2020 of George Floyd. Court is now obviously in recess. What we heard is victim impact statements, not only from the Floyd family, but we also heard from Derek Chauvin's mother, and we heard from lawyers on both sides. Judge Cahill will hand down Derek Chauvin's sentence when court resumes, and he said 2:45 p.m., that would be Minneapolis time. Let us bring in Keir Dougal, Jody Armour, and Lorenzo Boyd. Keir is a CBS News legal contributor, former federal prosecutor. Jody is a law professor at the University of Southern California Gould School of Law. Lorenzo is vice president for diversity and inclusion and the chief diversity officer at the University of New Haven. Keir, what do you make of the family's impact statements and what we've seen so far in this proceeding?
Right. One of the things that you often hear at sentencing and submissions on behalf of the defendant are comments about the effect on the family. And my general impression is that they do not, the family of the defendant. And my general impression is that they do not do a lot to move a judge, because the judge is going to simply say, well, the cause of this, these issues, the cause of the separation between you as defendant and your family is you. It was your conduct that in committing the crimes that the jury found you guilty of, that in fact is going to cause the disruption in Mr. Chauvin's family. The other thing that struck me about the hearing was the description of his conduct as torture, and a description of the charged crime as unintentional murder. That struck me as discordant. And the crime that he was charged with, or that the top count that he was convicted on, is often described as a felony murder charge, where the intent to commit another crime becomes the basis when the result is a homicide of a murder 2 charge. So although the prosecution here wasn't required to prove Mr. Chauvin's intent to kill, what that charge represented was proof that he intended to commit a different crime, a different felony, an assault that resulted in a murder. So I as a way of explaining this discordant set of discussions about an unintentional murder as defined under the law and torture, I think that's the way to resolve it. But that struck me about the hearing.
Jody, I want to ask you, Matthew Frank, the prosecutor, said that Derek Chauvin ignored his training, acted with, quote unquote, particular cruelty, and that George Floyd knew he was suffocating. That's why he was resisting on the ground. The defense attorney, Eric Nelson, said, yes, but there are mitigating factors. 19 years on the police department, volunteering for lots of different shifts. Otherwise, generally speaking, from the defense perspective, an honorable record as a Minneapolis Police Department. What is your overall assessment of those two arguments? And do you think in the end, they will move the judge from where he was when he walked into the courtroom initially this afternoon?
Yeah, well, the prosecution, as the top cop in the jurisdiction, is saying this isn't a problem with policing in general. Derek Chauvin is an aberration, an anomaly. We're going to sequester him, segregate him from law enforcement, and he did a particularly heinous, depraved act that we don't have to take any responsibility for. Derek Chauvin, on the other hand, was arguing I was doing what I was trained to do. I was actually following my training And if I did something wrong, then the department should be, and policing itself should be also on the hook for what's going on here. I shouldn't be scapegoated. And then I thought it was interesting that of course, the victim impact statements were powerful, compelling, gut-wrenching in their own right. I thought it was interesting to have the mother come on and speak and say, this is a human being. Much of the country looks at this person as a monster, purely and simply, as unmitigated evil in some way. And she said, you will not only be sentencing him, you will be sentencing me. And that's something that you've heard anti-incarceration, kind of decarceration people saying, that we need to think about the cost of imprisonment and the impact on the families. And a lot of those people are arguing against the new Jim Crow and racialized mass incarceration when they say that. So it's interesting to hear that argument now being made by the mother of a police officer saying, consider the price you're paying. And maybe, some would say, why don't we consider that price more? Maybe we should move in that direction more. But I suspect that the judge here is probably going to go in that, as Keir was saying, in that 20, 25 range, maybe 30.
Lorenzo, I want to ask you about Terrence Floyd, George Floyd's brother, who asked the judge not only for the maximum sentence, but he said, don't let this be a slap on the wrist. Our community has seen that enough. We don't want that in this case. That counteracts, or at least attempts to counteract, what Carolyn Palenti, Derek Chauvin's mother, said, asking for something much more lenient. Broadly speaking, how do you think those arguments will influence the judge and impact any future relationship in Minneapolis and nationwide between police and our communities?
Well, I think the whole world is watching at this point. And what a lot of people in the community are feeling, particularly those in the Black community, they're not necessarily hoping for justice. What they're looking for is the absence of injustice, because that's what a lot of people have been facing when police officers have gone rogue in the past and have done things like this, and they've gotten a slap on the wrist. So a lot of people are kind of optimistically hoping that the right thing is going to happen and that the judge will go a little bit more harshly than leniently. And I think that's what a lot of people want. And I think that would also be a good sign for most good police officers, because there are very few police officers out there that are siding with what Derek Chauvin has done. They want to distance themselves. Community members want to distance themselves. And again, we need to do this before we can heal and move forward. We have to acknowledge the pain, and somebody has to be held accountable. And levels of accountability are needed first, and then the healing process can go forward.
There are no shortage of voices on this particular story. I want to add another voice to our conversation. Jessica Levinson, she is a CBS News legal contributor and professor at Loyola Law School. Jessica, I want to ask you about something that Eric Nelson said, the defense attorney for Derek Chauvin, at the top of his proceeding. He said, this case lies at the epicenter of a cultural divide. Is that how it looks to you? Because it doesn't seem to me, yes, there are those who have taken up Derek Chauvin's cause in this, but it seems to me the preponderance of feeling in this country, not just among prosecutors, police, but the country at large, is this is a moment, a shocking, horrific moment, and it's not a divide. It's like a pursuit of justice to, if not redress previous injustice, but at least get it right in this case.
I completely agree with you, and I wish I could say something else, because it would make for a more interesting conversation if I said, well, yes, but on the other hand. And when I heard that, I just kind of shook my head and I thought, look, there's only so much that he can argue. And therefore, I think he's trying to say there's a schism. We heard Eric Nelson, the defense attorney, later say things like, I've heard from people on both sides, continuing this theme of, I know that a lot of people are pushing you to say that we should do something that's very stringent. But on the other hand, there's a lot of people pushing for something lenient. He said, they're both family men, really trying to, I think, treat this as almost an apples to apples situation. But no, I think you're exactly right that we have achieved as a nation, I think, largely a moment of reckoning about the criminal justice system, where we might have different views about how to get to a better place. But I think there's widespread acknowledgement that there has been systemic injustice. And this idea that the country is divided, at least from my perspective, is one that, it's one of the few things he has left to argue, but it's not a particularly compelling idea.
I want to ask you about the statistical part of Eric Nelson's presentation near the end, because he has to know, and the judge has to know, that whatever the statistical numbers suggest in previous sentencing of second-degree murder cases, this one is different, that it's different for a law enforcement officer. It's different if the judge has already agreed that there's an aggravating circumstance based on lack of carrying out that requirement of being a police officer, carrying out the public trust. I guess he has to argue that way as best he can, but he also has to know deep down inside that that is probably unlikely to persuade the judge.
I think so. And frankly, I feel like I had a little deja vu all over again from watching the trial, where I remember having a conversation and saying, look, there's only so many places he can go with this case. And I think there's only so many places he can go with this sentencing. Now, if we look at the sentencing, yes, presumptively, you are looking for a first offender at 12.5 years in Minnesota for second-degree murder. But there's so many things, as we said, about this situation that are unique. The aggravating factors that were mentioned, the issues of children being there, the duty of care, the particular cruelty. Now, there is something, however, I think that's in favor of seeing a lighter sentence, which is there is a fairly old, or it's just a few decades old, Supreme Court case where the court acknowledges it dealt with a Los Angeles Police Department officer. And the court acknowledges when it comes to putting police officers in prison, they're probably going to be in solitary for their own protection. And that type of solitary confinement with which Officer Chauvin is now serving can be, in fact, a harder psychological type of time. So that could be viewed as a mitigating factor. Having said all that, I don't think the statistics here, I mean, we're talking about a defense attorney who asked for probation. You know, he has a duty under the law to vigorously advocate for his client. It doesn't mean that his advocacy is going to win the day. And in this case, I don't think it will.
Right. It's worth pointing out that neither attorney, neither the defense attorney nor the prosecutor spent very much time, if any, on the probation part of this conversation. Kira, I want to ask you about something that Derek Chauvin said. He was given an opportunity to speak to the court. He offered condolences to the Floyd family. And then he said something I'd like to get your reaction, whatever it might be, to saying, as he turned to the family, there's other information that may come out, and I'm paraphrasing here, that may give you some peace of mind. Any reaction to that from your courtroom experience or your understanding of the law or what he might have been driving at?
I don't know. It seemed very speculative to me. It almost, it didn't seem particularly helpful to me. You know, the circumstances here, he's charged in a federal case. His ability to speak here is limited because, as we mentioned earlier, he can hurt himself with what he says. If he says something that is incriminatory or directly related to the conduct that he's being sentenced for now. So he was on very tricky ground. But that particular remark, I thought was, you know, like teasing something that he knows it's going to come out. I thought was not particularly helpful. And frankly, my reaction would be one of being unsettled. If I were in Mr. Floyd's family, I would be unsettled by that. I'm not sure that that's helpful at all.
Lorenzo, if I could, let me ask you about the totality of not only what Derek Chauvin said, what briefly he said, but also what his mother, Carolyn Palenti, said. There was no reference from his mother, and we can all understand a mother's love for her son and advocacy for her son in any set of circumstances. But she didn't say anything to the Floyd family in general or in specific. And she said, I still believe in your innocence. And to the earlier conversation we had, when you sentence Derek Chauvin, Judge, you're also sentencing me, deeply personalizing this, but not sending anything of a personal condolence in the direction of the Floyd family. In general, how do you think that will be viewed within the community at large and those watching this trial very, very closely?
Well, as we're watching this and as we're doing this in live time, I'm actually paying attention to social media and Twitter. And a lot of people are saying all sorts of negative things about those comments. We expect that from a mother, but the fact that it didn't speak at all to the death in the Floyd family, didn't send condolences at all, that actually didn't resonate at all with a lot of people on social media. And I think it was problematic in the fact that we have lost a life here. Somebody is dead because of the actions of your son, but yet you still paint him as an angel. That did not resonate on social media at all. And I don't think that was helpful at all, but it's also not unexpected. That is what we expect a mom to say about her child.
Just to reset the situation for our audience here, Judge Peter Cahill, presiding, has said he will come back to the courtroom 2:45 local time. That's about 2.5, 3 minutes away, if in fact he does come at that time. Jody, I want to just give you an open-ended question here based on the things we've talked about or things we haven't yet talked about that you think are worth elevating before Judge Cahill comes back to the bench.
Just that it's interesting that we're in a moment of accountability, demanding accountability for police misconduct. At the same time, we're at a historical moment when we're asking ourselves to rethink blame and punishment, to move away from retribution, retaliation, and revenge as a way of approaching even violent criminals and move toward restoration, redemption, and rehabilitation. You saw Larry Krasner in Philadelphia beat down, trounce an opponent in his second run, Chase Boudin up in San Francisco, George Gascon down here in LA. A lot of voters are getting behind a new way of approaching and thinking about blame and punishment that doesn't really kind of play on this kind of script that we're seeing today, which is understandable, that maybe the way you show you care is by heaping more punishment on the victimizer, right? But that moral compass got us 30, 40 years of racialized mass incarceration that we called the new Jim Crow. So it's a moment for us to sit back and reckon with and think about that tension.
Jody, thank you very much for your thoughts. Control room, where are we? Do we see? We're still waiting for Judge Cahill to come back to the bench. I want to continue the conversation. Keir, help the audience from your experience as a former federal prosecutor. What are we likely to see? Is this going to be right? As soon as he gets to the bench, he's going to start saying this and we're going to get to the meat of this matter?
I think he'll get to it pretty quickly, but I expect that he may make remarks about the two versions of Derek Chauvin that you see in a sentencing of a defendant, right? So you see the conduct, the horrible conduct throughout the trial, and then you see at sentencing the picture the alternate picture of a loving son, of a father, of someone who was devoted to his job on the police department, portrayed as someone who was trying to be a good member of society. And this is why every judge that I've ever heard speak about sentencing says that this is the most difficult part of their job. They have to reconcile what they see in the trial with the sentencing presentation by the defense and in the PSR of someone like this with no prior criminal history of behaving in completely different ways. So I think you may see the judge acknowledge the presentations on both sides and the two versions of Derek Chauvin that have been presented to us. And then I think quickly you'll understand, or you'll get to how the judge sees the case.
And Keir, understanding that we're under the time elements here, if the judge walks back in, I'm going to have to cut you off. But as I understand it, it was put before the judge to decide if these other aggravating circumstances existed, not before the jury. Does that matter, and is that important in any way that we should be thinking about?
Well, it matters in the sense that it allows the judge to depart upward. As we've also heard, the mitigating factors, perhaps the idea that he will be in solitary confinement as a mitigating factor is something that the judge may weigh to counterbalance those things. But the judge has a lot of discretion now. As we started off, the polls here are 30 years on the one hand asked by the prosecutor, probation and time served on the other. The judge really could land anywhere in that range, but I expect it to be closer to 30 given the circumstances here.
Renzo, again, understanding that we're under a tight time constraint, possibly the judge could walk in at any minute, but I want to give you an opportunity, and I don't want to put undue pressure on you speaking for everyone in the quote unquote community, but in general, based on your experience, your lived experience, the conversations you have and are having, what do you think the level of anticipation is across the country right now as we wait for Judge Cahill to come back to the bench?
I think most people are thinking that it's going to go a little longer than shorter. There's still a lot of people who think that history has shown us that we don't do a really good job holding bad cops accountable. So a lot of people are bracing for that. But even when I'm training police officers around the country and talking to them privately, even they're saying that this was really bad and that this should be a pretty long sentence.
This is really bad. And they also say, I wonder if you are hearing, it's an anomaly. It's so outside of bounds. It's not really a part or shouldn't be a part of overall police reform in general. Are you hearing that pushback? And if you are, do you believe that is justified?
I am hearing that. No, I don't think it's justified at all, because all of this plays into what reform is. We're trying to make policing better, and we keep hearing time and time again that there's one or two bad apples. Well, actually, there's a whole lot of bad apples, and we need police reform. We need it from the legislative perspective. We cannot expect policing to fix itself. So we need all sorts of intervention from all sorts of places to let the good police officers continue to be good officers, but hold the bad officers accountable.
Lorenzo, let me pick up on that. When you say we need reforms, if you could, one or two that you think would be essential to this conversation, essential to a new reality in the way police officers interact, de-escalate or deconflict situations that in the past have led to the use of lethal force.
I think the problem is we start at the point where the citizen and the police officer come in contact with each other. We need to go way before that. Instead of reimagining policing, we need to reimagine training. We need to increase levels of empathy and compassion. We need to increase critical thinking skills and communication skills. We need to get police officers out of the car into the community. We need police officers to understand the lived experience of the people that they're policing. That way, the police won't seem like an occupying army of outsiders, and they'll seem like they're part of the community. That's where we need to start with policing. We need to overhaul policing the whole way we do it, the whole way we do training. And I think we can do that, but we need legislative help doing it.
Lorenzo, I'm going to continue this conversation with you because it's an important topic and you have some particularly powerful insights. I've covered legislatures in Washington, the Congress, since 1990. I've also paid a lot of attention to state legislatures, and I can hear them saying already, wait a minute, Lorenzo, all the things you described are kind of atmospheric. They're holistic. We write laws with specific language and specific words that are scrutinized for years and years afterwards. How do we come up with legislative language that begins to put into paper and put into action what you've just described?
I think it's about how the laws are written. First of all, to say that using a chokehold is against policy tells me I can still do it, but I'll get a slap on the hand. But saying that using a chokehold is illegal and we will then charge you criminally is a very different thing. The level of accountability that we need starts there. And to borrow the final summation from the OJ trial, who polices the police? We can't allow the police to do that. We need legislative reform at a national level.
On the bench. We are going to pause for a moment in our coverage so we can begin a CBS News special report. This is a CBS News special report. Good afternoon, everyone. I'm Major Garrett in Washington. The nation's eyes are on a courtroom in Minneapolis as former Officer Derek Chauvin is sentenced for murdering George Floyd. He faces a maximum of 40 years. Judge Peter Cahill is about to deliver the sentence. Let us listen in.
That you took the time to stay with this case and to provide me with input. I have reviewed the pre-sentence investigation and carefully considered all the facts, the case, and the law. But my comments are actually going to be very brief because most of it's going to be in writing. I have a 22-page memorandum that is going to be attached to the sentencing order. And why am I doing it in writing? To emphasize the fact that determining the appropriate sentence in any case, and in this case, is a legal analysis. It's applying the rule of law to the facts of an individual and specific case. And that is why, as opposed to trying to being profound here on the record, I prefer that you read the legal analysis that explains how I determined the sentence in this case. What the case is, or what the sentence is not based on, is emotion or sympathy. But at the same time, I want to acknowledge the deep and tremendous pain that all the families are feeling, especially the Floyd family. You have our sympathies. And I acknowledge and hear the pain that you are feeling. I acknowledge the pain not only of those in this courtroom, but the Floyd family who are outside this courtroom and other members of the community. It has been painful throughout Hennepin County, throughout the state of Minnesota, and even the country. But most importantly, we need to recognize the pain of the Floyd family. I'm not going to attempt to be profound or clever because it's not the appropriate time. I'm not basing my sentence also on public opinion. I'm not basing it on any attempt to send any messages. A trial court judge, the job of a trial court judge is to apply the law to specific facts and to deal with individual cases. And so, Mr. Chauvin, as to count one, based on the verdict of the jury finding you guilty of unintentional second-degree murder while committing a felony under Minnesota Statute 609.19 subdivision 2 paren 1, it is the judgment of the court that you now stand convicted of that offense. Pursuant to Minnesota Statute section 609.04, counts 2 and 3 will remain unadjudicated as they are lesser offenses of count 1. As a sentence for count 1, the court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270. That is a 10-year addition to the presumptive sentence of 150 months. This is based on your abuse of a position of trust and authority, and also the particular cruelty shown to George Floyd. You're granted credit for 199 days already served. Pay the mandatory surcharge of $78 to be paid from prison wages. You're prohibited from possessing firearms, ammunition, or explosives for the remainder of your life. Provide a DNA sample as required by law. Register as a predatory offender as required by law. And then you will receive a copy of the order and also the attached memorandum explaining the court's analysis. Anything further from the state?
If this needs to be said, we just ask that it be executed forthwith.
Defendant is remanded to the custody of the sheriff to be transported back to the DOC or whichever custody is currently holding him. Anything from the defense? No, Your Honor. All right, thank you. We are adjourned.
Judge Peter Cahill has just announced the sentence of former Minneapolis police officer Derek Chauvin, 22.5 years. Jamie Yukas of CBS has covered this court case from the very beginning. She joins us now from Minneapolis. Jamie, set the scene if there's any reaction out there or what you have your own reaction based on what you heard before this verdict being announced there in Minneapolis.
Well, I think everyone, including the crowd behind me in front of the government center, was surprised when Derek Chauvin's mother came up and addressed the courtroom. Many people there not happy about it. She obviously had a very tough time going through. Derek Chauvin also addressing very briefly, could not make a large statement, said that he has some legal issues that he has to clear up before he makes a formal public statement, but did say that he did feel remorse for the Floyd family. That's the first time we have heard him say something like that. I believe you're seeing pictures from right outside the courthouse right now where some demonstrators had gathered. 22.5 years was what many people thought would in fact happen. They thought anywhere from 20 to 25 because of those aggravating factors that the judge would take into consideration. It's interesting that he noted in the particular cruelty that was laid upon George Floyd during the 9.5 minutes that Derek Chauvin was on Floyd's neck as the aggravating factor that he took into account. That's something that we will take a look at, many years to come as to how he made this decision. Again, he said that he has a 22-page written statement that he's going to add to what happened today with the sentencing. So we will see in detail. That was a little bit of a surprise too, Major, that he didn't come out. Many legal experts had thought that he would give very detailed and specific reasons as to why he came to that 22.5-year sentence. Again, that's about 10 years longer than the Minnesota state guidelines would have given Derek Chauvin based on the fact that he had no prior criminal record. His attorney, Eric Nelson, the defense attorney, had stated that he is concerned about Derek Chauvin's safety. That was a reason that the defense had asked for probation in this case with time served. Now, Derek Chauvin will get credit for about 199 days. That's how long he's been in prison. We know he's in solitary confinement at this point. And again, as the sentence was being read, it was interesting to note that he did not show much emotion in this case. From start to finish. Major?
Jamie Yuccas, thank you very much. CBS News legal contributor and civil rights attorney Alexis Hogue joins us. Alexis, the prosecution asked for 30 years. The judge handed down 22.5 years. He said that sentence was not based on emotion, sympathy, public opinion, or messaging. Your reaction?
Yeah, good afternoon, Major. I can't say that I'm surprised by this sentence. I think back to former police officer in Minnesota, Mohammed Noor, who was actually convicted of a lesser account, so third-degree murder, and received a 12.5-year sentence. So I knew going into it, because Chauvin was convicted of a greater crime, second-degree murder, that he would receive longer than 12.5 years. And even though Judge Cahill did not speak to emotion and sentiment, this is a very carefully and closely watched case, not just in Minnesota, but all around this nation and really around the world. And I think he felt the weight of that. And he very much is still within the framework of what Minnesota law allows for him to sentence Mr. Chauvin. So I can't say that I'm surprised, and I'm eager to read his 22-page memo.
I'm sure you are. Alexis, before I let you go, for those who would have liked to have seen 30 years or maybe even the maximum of 40 years because they considered this crime so brutal, what would you say to them as they work through the processing of this announced sentence?
Even with the convictions that we heard in April at the conclusion of the trial, the convictions, the sentence, they don't really speak to the underlying concerns that still exist, which is that Black people, brown people, people of color experience greater degrees of violence when they have contact with the criminal legal system, with police officers. And so these are unaddressed issues that this sentence, even the maximum amount of sentence, wouldn't address. And so I think it's so important to focus on moving forward for Mr. Floyd's family. I'm hopeful that this sentence gives them some amount of relief, but it doesn't solve our problems. And this is why I am heartened to see the crowds, the vocal crowds in Minneapolis that are as concerned and as committed to really overhauling the way that police officers interact with the public.
Thank you very much. I want to bring in now CBS News legal analyst Ricky Kleeman. Ricky, it's an oversimplified question to say, what's your reaction? But I'm going to do it anyway. What's your reaction?
My reaction is that I am not surprised by the sentence. I think many of us who have taken our lives and dealt with the criminal justice system as both prosecutors and defenders, as I have, would have expected a sentence between 20 and 30 years. So he was well within that range. There was not really a path to give Derek Chauvin the presumptive sentence in light of the aggravators that were put forth by the prosecution and explained by the prosecutor today, particularly the act of cruelty of Derek Chauvin, as well as looking at his abuse of authority. I thought the prosecutor's argument was highly persuasive in court about the fact that when you have someone in custody, he is in your care, and that Derek Chauvin did not show care to George Floyd. I think that there will be people who are disappointed that he did not get this quote unquote maximum, which is 30 years, but certainly 22.5 years is a very substantial sentence when, without the aggravators, unintentional murder, which is the conviction in this case of second-degree felony murder, unintentional murder, that really would have carried a presumptive of 12.5. I think that people like lawyers and academics will think that the sentence was very fair. People in the community might not.
Ricky, I want to have you listen, and the audience as well, to Derek Chauvin. He spoke ever so briefly. It was a dramatic and brief moment within the courtroom. He is still appealing his conviction, probably one of the reasons his comments were so brief, but he did, for the first time, address the Floyd family. Let's listen.
I want to give my condolences to the Floyd family. There's going to be some other information in the future that would be of interest, and I hope things will give you some peace of mind. Thank you.
Ricky, I'm not trying to ask you the most difficult question here, which is, what is that about? But do you think that there's anything in the totality of the condolences, but also there's going to be more information that might give you some peace of mind? I'm just not sure how that would land with the Floyd family. It seems like a one and the other kind of thing.
Well, it's really, I think, a bizarre statement, and I think that's kind coming from me. I think it would have been fine if all he said was that he wanted to give his condolences to the Floyd family. We would have heard him say that. I don't think it would make any difference to the Floyd family, nor perhaps should it make any difference, but at least it would be some kind of contrition. But this little carrot and stick approach of saying, well, there's more to come. I just found that not only bizarre, it's almost in its own way sadistic. It's like a nasty tease. If I were his lawyer and had vetted what he was going to say, I would have never permitted him to utter that second or third sentence. It was, I guess, the phrase that we have shared amongst ourselves is that it's like gaslighting. It was not only not in good taste, it was about the last thing that the Floyd family and all of their grieving needed today.
Right. I don't think anyone in that courtroom expected Derek Chauvin to basically say, stay tuned. Ricky Kleeman, thank you so much for your help. I want to bring in Dr. Ibram X. Kendi, CBS News contributor and lead anti-racist scholar. Dr. Kendi, you've probably watched the proceedings, your overall assessment.
Well, first, I'm hoping that the Floyd family, that this sentencing today could ease some of their grieving. I'm certainly, I thought that he should have gotten more years in prison, and the reason being is because one of the ways we should consider these types of cases is if George Floyd would have been convicted of unintentional murder of Derek Chauvin, would he have only gotten 22 and a half years? You know, that's the type of equal punishment that I think people in the community are looking for. But at the same time, it is so rare for a police officer to be convicted and sentenced for this long. And so I'm hoping that it certainly provides some ease for the Floyd family.
Dr. Kendi, I want to ask you about the way this whole case began. You know, I know, many of the American people know the sanitized version the Minneapolis Police Department originally released about George Floyd's death. That was not true. That was a non-factual assertion of what happened. That was blown up by the facts and citizens who were there, who recorded this for all time on their cell phone video. That part of the story is somewhat forgotten, but it seems crucial to me as we look at the arc of what this is and what it may represent in the future. I'd like your thoughts on that.
Major, I'm happy you reminded us of that, because when we think of the murder of George Floyd, we're not going to be able to separate it from the series of demonstrations, you know, millions of people from coast to coast, from the largest of cities to the smallest of towns, people of all races and ages who came together and demonstrated, you know, against racism and police violence, who saw the murder of George Floyd in all of its horror, and it drove them to speak out and to call forth for a complete transformation of our, you know, criminal legal system. And that may not have happened, right? If the official report, the official police report would have held the day. And I think it just allows us to really step back. And unfortunately, when there is police violence, is it possible for us to believe the word of the police. And I think this case shows us that it's not.
Dr. Ibrahim X. Kendi, I want to thank you very much for joining us once again to remind the audience what just happened. Former Minneapolis police officer Derek Chauvin has been sentenced to 22.5 years for second-degree murder in the death of George Floyd. Our coverage of this ongoing story continues, of course, on our 24-hour streaming service. That is CBSN. You can watch it at cbsnews.com or download our CBS News app on your phone or connected TV. There will be more on your local news on this CBS station and tonight on the CBS Evening News. This has been a CBS News Special Report. I'm Major Garrett in Washington.
For news 24 hours a day.